The eagerly awaited Supreme Court battle began in earnest today. Like gladiators of ancient Rome, senior counsel from both sides took to the Supreme Court stage with zeal and calculated intent to inspire fear amongst themselves and amongst the supporters of both sides, and also to inspire hope that in the end something good may come out of it. As we wait, we saw senior counsel leaving no stone unturned, as evidenced by AC James Korengo when he discredited with so much wit the affidavit by one Hilda Kavonga, whom he said mutated to a male person by the name Martin Wachira. Every opportunity counted to attack the other side, and that attack was made with precision. Small wins were celebrated. Time, of all things, became the most precious commodity, as counsel argued fervently that they should be added more. In the end, we have to look at how the whole process impacts the main players between Ruto, DP Ruto and Raila Odinga. One man emerged the winner, and that is Raila Odinga, fending off Deputy President Ruto's attempt to strike out the valuable affidavits by the 6 commissioners, 4 of which support Raila's petition, and also the rest, or rather the support that Raila is receiving from Law Society of Kenya as amicus curiae. What does this mean to Raila Odinga in the long run? What does it mean to him? That is our question for the day, ladies and gentlemen. We welcome you to this episode of The Nationalist. I'm your host and analyst, Kennedy Abongo. Before I proceed, do take a moment to subscribe and click that notification bell so that you're notified whenever we post videos like these ones. I'll give you a moment to subscribe. Okay, now, I hope you have subscribed. On to the topic of today. What does it mean to Raila to have Ruto's application thrown out? How is he going to benefit? In war, people begin by making oral arguments before the actual fist fight. People throw mind games here and there so that you can gain an advantage. In legal proceedings or processes like this one, the small wins that somebody gains through applications and response or counter applications are very valuable to the case generally. And therefore, for Raila to have the application by Ruto thrown out, there are 5 major ways that will benefit him. And those are what we are going to discuss today. What does it mean to Raila to have Ruto's application thrown out? Number 1, Raila Odinga will be able to demonstrate or show that the technology deployed did not meet the standard of integrity, the standard of verifiability, the standard of security, and the standard of transparency to guarantee accurate and verifiable presidential results. Affidavit by Justice Nyang'aya, for instance, will deal with these issues because it makes claims that third parties infiltrated IEBC servers. Affidavit also by John Githongo will be very crucial in corroborating that part of evidence. And of course, the further affidavit which Githongo filed and which has been allowed by court today, will be very crucial in dealing with this particular allegation by Raila Odinga. As you are also aware, there have been allegations that the issue of form turning into PDF rather than the JPEG when they arrived at the IEBC public portal. That speaks to security issue, which is very critical in the deployed technology. So when you consider all those factors, or the arguments that I've made with respect to the affidavits that I've mentioned, Raila will be able to at least answer the first issue as framed by the Supreme Court judges, whether the technology met the standards of integrity, verifiability, security, and transparency to guarantee a fair and verifiable results. Number 2, Right Honorable Raila Odinga will be able to show that there was some sort of interference of uploading results from the polling station to the IEBC public portal. Once again, Commissioner Nyangaya's affidavit will be very instrumental in this respect. He claims in his affidavit that there was someone who, once this Form 34As were sent from the polling station, somebody somewhere downloaded them and then re-uploaded afresh, essentially saying that there was some sort of interference. Githongo's affidavit also emphasizes this, speaking about the team which constitute 56 people who are specifically employed to interfere and tamper with the results. The affidavits, therefore, will answer quite easily the issue number 2. The issue of whether the Githongo's affidavit, the probative value of Githongo's affidavit is another issue. But the fact that that affidavit is now before court, and affidavit is evidence, something made under oath, ensures that Raila has a stronger case in answering the issue number 2 as framed by the Supreme Court judges. Number 3, the former PM will also be able to demonstrate with ease that the IEBC did not carry out verification, tallying, and declaration of results in accordance with Article 138(3)(c) and Article 138(10) of the Constitution. If you look at the affidavits by the 4 commissioners generally, what they are saying is that Mr. Chebukati, the chairman of IBC, approached them with results which he said were tallied at the back room. He's the only one who knew those people, and is the only one who set up that back room for purposes of tallying the presidential results. And therefore, the question that the court raised as issue number 6 was whether the IEBC carried out a verification, tallying, and declaration of results. There are questions about 27 constituencies which had not been declared. Allegations are flying here and there. Some are saying they had been verified. Others are saying they had not been verified at the time of a declaration of the presidential results. The affidavits by the commissioners will be very, very crucial in answering that particular issue number 6 as framed by the Supreme Court. The 4th way in which Raila will benefit is that Honorable Raila will be able to benefit from the affidavits with respect to his allegation of irregularities and illegalities that affect the presidential results. The issue of illegalities and irregularities coming from the commissioners themselves, that they are asserting that there was some illegalities. In fact, some are saying disowning the results in itself shows that the illegalities affected the presidential results. Chebukati acting as if he's running the commission as if it is his home or personal property. Did that affect the results? Is that an illegality under the law? The commissioners' affidavits, especially the 4, will be very important in answering or assisting Raila in dealing with that particular issue as raised by the Supreme Court. Lastly, and that is the 5th one, Right Honorable Raila Odinga will benefit greatly from the submissions by Law Society of Kenya because they support his position that rejected votes must form part of the total votes cast as envisaged in Article 138(4)(a) of the Constitution. There have been arguments flying around with respect to this, the interpretation of Article 138(4)(a). What is the meaning of total votes cast? The bit of dispute or the point of concern is how the Supreme Court in 2013 and the Supreme Court of 2017 under Maraga interpreted what it means to be what total votes cast mean. In those 2 instances, the Supreme Court held that only valid votes can be used towards tallying or calculating who the presidential winner is. This time, however, we now have the Law Society of Kenya coming on board supporting Raila's argument that rejected votes ought to form part of that calculation or the total votes cast, because rejected votes find their way inside the ballot box, meaning they are cast in the ballot box. And in fact, rejected votes can only be identified at the point of counting, but they were cast. We do believe that the Supreme Court will also provide direction on this particular issue, because in the last two petitions, it has insisted that only valid votes are used. We are really looking forward to this particular one, how the Supreme Court will deal with it. So, should Azimio supporters be happy with the happenings of today? The war has just begun. You are allowed to celebrate this win. However, you have to also realize that Deputy President William Ruto also landed a major blow that has now provided him with some direction on how to mount his defense. The response by Counsel Mansuru on behalf of IEBC, or on behalf of the other faction of IEBC, which supported Raila Odinga's petition in a way, is now out of the record. The Supreme Court technically threw that response out of the record because in practice there is something called notice of appointment. An advocate must have a notice of appointment which gives you the authority to act. So when the Supreme Court struck out that notice of appointment, it meant that every other pleading or every other document which was filed following that notice of appointment is no longer part of the court records. They fall with that notice of appointment. And therefore the participation of IEBC or that faction of IEBC stopped today. It is quite interesting, though, that the Supreme Court went ahead and stated that they would not want to be dragged into the war of the IEBC or how they should administer themselves. And therefore, I did not find it quite reasonable that the Supreme Court would then proceed to remove the response or strike out from the court record the notice of appointment of Mansour to act on behalf of the other faction of IEBC. And therefore, that is where now what we call the politics of judging comes in. Probably they felt that the application of Ruto was struck out. So it was something also to give the other side to celebrate about. We are not yet out of the woods. The proceedings will only get murkier. No worries. Stay here with us. We'll update you as things go on. And therefore subscribe, like, comment, share these videos. Also click that notification bell so that you are notified whenever we post. I'd like to thank you for watching this video. See you soon when we're going to make another